Good afternoon and welcome to Living in the Promised Land. I'm your host, Mark Schmorley, and um, today we have an amazing guest, George Pappas, who we'll get to in a second. I just wanted to, as I do, update you on what we're going to be talking about next and what's also in the news, and that is the ending of temporary protected status, which, as we've talked about before, means that all these people who have been protected um, in the United States, who were first protected because there was either a natural disaster or political upheaval, and it was not safe for them to return. And so temporary protected status ended for Syria, and it ended for, more importantly, in the United States, for Haitians. And right now, they have not done a mass deportation. They've warned on it. They have not done it. And today we saw in the news that they have said that they're just going to put everybody, all the Haitians are going to be called in whose TPS expired to get ankle bracelets to so that. And when you go to ICE and you see in the room, as I do, you see these boxes there and they'll just fit people in them, and it's all a business. And I believe that business is also owned by Geo Corporation, which is which runs many of the prisons, and so that's something that's happening in Springfield, Ohio, where we were in Massachusetts, and of course in South Florida are the three largest populations. But um, around where I am, and really throughout the country, is the concern that next month, September 9th, TPS for people from El Salvador, which has existed since 2001, is going to expire. And so people are scared and they're worried, and they've been here forever and they have kids, and, you know, and so that's really, those are two things that are concerning. And we're going to have J.S. Rathod from Georgetown University, professor from Georgetown University, on the next episode to talk about that. But what we're going to talk about today, we're going to revisit immigration courts. We spoke with Judge Slavin last fall, and she was also working on Alligator Alcatraz. And Judge Slavin had been retired for a while, but today we have George Pappas, who was an immigration judge until last year. He had been in private practice before that, and he was on the chopping block along with many others. And so, and George is now back in private practice. He is doing a lot of work around the country. He's recording videos that people that know him by now, short videos, which are great to explain what's going on and to really keep us up to date. And so, at the end, he'll give his, and we'll put in the show notes his links. Are you on Instagram or just Facebook?
Yes,
Good, good. So you're not. We don't have to say "Okay, Boomer" to us today. We're on Instagram and TikTok and things that are more out there, and Facebook. I know they're on Facebook too. That's what we use. So it's uh, that's great. So George, welcome.
thank you. Thank you for inviting me. I look forward
So
to speaking to your audience.
yeah, thank you. So I want to start off to talk about your Odyssey, seeing as that is the word of the month. Your Odyssey from, when did you start your legal career?
When did I start my legal career? I was about 41 years old when I started my legal career. My legal career is career number two. Uh, I was an international commodities trader. I mean, paper trader. I actually moved commodities on steamships and rail cars for 20 years.
Wow.
And I supplied many of the book printers and magazine printers in this country with that commodity printing paper. So I did that for about 20 years. But halfway through that career, um, I decided to go back to law school. Unlike most law schools here in the United States, I enrolled with the University of London because to go to a law school in the US, I'd have to give up my career. And I wasn't going to give up my career. So fortunately, the University of London had a program that was flexible enough for me to earn my LLB, not JD. Just for those of you that don't know, the JD used to be an LLB, but they changed the label around 1960.
Mm,
Uh, And it is not a doctorate degree, even though it's called a Juris Doctor. It's not a doctorate degree. That's another discussion. But that odyssey began for me around 41 years old. Obviously, I went to school when I was around 35 for law school. So it was a mid-career change for me. And I started in private practice probably around 2003. And within 2 or 3 years, after doing family law and criminal defense, I segued into immigration and never left. So really, from 2006, I've been pretty much doing immigration everywhere. But I was based out of North Carolina in the beginning, but as the practice
Sure.
grew, the clients came from everywhere. And so that was my immigration journey. And, over 20 years, I had my own law firm before I became a judge. And I did virtually everything except asylum. That's the only
Mm.
part that I didn't do. I was in the Fourth Circuit, nestled between Charlotte and Atlanta, two horrifically high denial rates. And I didn't want to waste people's money knowing that those two courts were against my clients. So I did cancellation of removal, I did adjustment of status, I did, consular processing, and I did all the other issues out of USCIS from adjustment of status and citizenship and waivers and military parole in place, just about everything I can get my hands on. It wasn't until I became a judge that virtually 90% of my time was doing asylum. So, of course, now I'm doing asylum as
Sure.
well.
Right. And
And
that's what
the
you see as a judge.
horrific denial rate is no longer isolated to Atlanta and Charlotte. It's now nationwide.
Yes.
So that's a summary of
Right.
how I came into the profession.
So you were people don't people are always confused and likely, I mean, it doesn't make sense if you're not in the government how the government works. So being here in DC, I have, friends in the government, but I have never worked directly for the government, but having been very involved in the federal bar, I've learned how that all works, but it's a very strange thing to people because um, you know, eh, when I used to work at the Organization of American States teaching English, I would work out at the Department of the Interior, use their gym, and that was the first time I met and a judge, and someone said he's not a real judge, he's an ALJ, and then I went to law school, administrative law judge. So most administrative law is done in, I think the vast majority is Social Security. I think as we used to be, and so people think of like administrative law where people are fighting regulations, but immigration court is people and deportation in jails, but it's a civil court. So people don't, I still don't think when I explain to people, no, you're not a judge in the sense you are an employee, and they've made that very clear when they talk to the union. You're an employee of the Department of Justice, and they can move you to another job. Is that right? So you're hired from within. You're a government employee, but there is and in the body of law to follow. There is something called the Board of Immigration Appeals, and you talked about the circuits. So for people, those are federal courts that govern certain areas, and the Fourth Circuit is from North Carolina really to Maryland and all in between, and then West Virginia, and then the 11th Circuit is Florida, and it's Florida, Alabama is in the 11th, and then Georgia. It's based in
You're
Atlanta. So
right.
yeah,
This
so
is something most people don't understand or appreciate.
yeah,
Immigration judges are employees of the Department of Justice. Immigration judges are appointed by the U.S. Attorney General. And the U.S. Attorney General, uh, which oversees the Department of Justice, is part of the executive branch of our government. The President of the United States appoints the Attorney General. So we're part of the executive. We're not part of the judiciary. Those are called Article 3 courts. They're independent. President Trump, for example, can't fire them. But we're not in that category. We're in a different place in the executive branch, and we deal with far more pressure in terms of influencing our decisions or being fired or being threatened than any other judge would have to deal with. So keep in mind, immigration judges, they do wear a robe, they have a courtroom, they have a flag, they have a seal, but I can tell you it is not as independent as the judges that you're familiar with who operate as part of the judiciary. And so since January of 2025, just to prove the point, the president, through the attorney general, has fired over 116 judges. Three were fired last week at it. Three out of Chicago, one out of Sacramento. And so think about it, 116 judges have been fired, not for any reason, without any cause. The only explanation all of us have received by email is that we're not going to retain your services anymore under Article 2 of the Constitution. Pack your bags up. See you in 15 minutes. That's it. And that memo went out to people that have worked in the government for 33 years. They've been judges for over 20. And talk about a royal slap in the face after all that service and effort and knowledge and experience just tossed out into the street. So that's why we're more vulnerable. However, despite the pressure that we're under because we're part of the executive, immigration judges are still required under regulation and under the Constitution to promote fair hearings and due process in immigration court proceedings. In other words, the government cannot tell a judge how to decide in a specific case. They can certainly advise judges how to manage their docket, but when it comes to time, when the time comes to review the facts and the merits of a case, the judge must exercise independent judgment. And that's where this administration has really overstepped the boundary. They have gone over that boundary, telling judges if you don't rule in a certain way, you might as well get a different career or we will fire you. That threat came out in June 27th, 2025,
So
from
was
a
that the
policy.
first? So let's go back and just so people can have a timeline of how did this happen. So, when you apply to be a judge, you apply through like how do you become a judge?
I applied through USA.jobs. I saw an advertisement for immigration judges, and after practicing law for 20 years, I felt I was qualified. And I was right. I submitted my application, and you had to have so many years of experience in immigration law just to apply. And so I applied, and within 2 or 3 months, I was told that I was being hired, and the onboarding process was brutal. I only had 8 days to close down my practice and report to Falls Church, Virginia. That was really an unbelievable transition. It was hardly pleasant. But I was hired. And then we trained for about a month. We really got familiar with the tools and the gadgets and the machinery that judges use. We had to learn all of that. And then as soon as we finished that training, we went through an investiture, and the then Attorney General, Merrick Garland, swore us in at the Department of State. And then that 2 days later, we all reported to our respective courts. I flew straight from Washington to Boston to report to the immigration court in Boston in August of 23. So that's how I applied. That's how I was hired. That's how I was trained. And that's how I started.
So, what were you told? I mean, you were told that you could be independent once you knew what was there. You were told that there were no. I mean, your training had no uh, bent to it as far as what your job was, and you were sent on. Once you were hired, you were just sent on your way up to Chelmsford, Mass, and to do a regular docket, and then you just started taking cases.
That's right. I mean, we became, for those of us that were practicing, a lot of the training was not new. We knew about immigration law. We knew about asylum. A lot of the other judges that were hired were new to immigration. So for them, the learning curve was steeper. But we were reminded what the law was. We spent a lot of time on what our role was. We were not there to take sides. We were there to address the controversy between what the immigrant was trying to apply for versus what the Department of Homeland Security was trying to prove. Primarily, they were seeking to deport people or to challenge the credibility of an immigrant. But we were told to listen to the facts, try to use the law and the regulations as best as you can to make a good decision, and you do your best. And of course, if you made the wrong decision, the parties can appeal you. They can go to the Board of Immigration of Appeals. Um, and that's what we did. I can tell you that politics never played a role. Once those doors closed and we were in the immigration court, wearing that robe put a lot of responsibility on our shoulders. We knew that there were lives at stake, families at stake, and we made sure that we prepped our cases before they were heard. We knew the issues. We read the testimony. We read the country reports. We read the evidence that supported all of that. Of course, we read the legal briefs that were filed by the attorneys. So even before we heard the case, we knew what the landscape was. That took a lot of work. It was either done the day before or the week before. But when we walked into that courtroom, we now wanted to hear the testimony. We wanted to see the demeanor of the respondent. We wanted to see how they did against cross-examination. We wanted to see how well their attorney prepared the case. So, and at the end of the day, after we heard everything, probably 90% of the time, I would issue an oral decision on the spot. I would make a decision on the spot, and I would spend about 40 minutes dictating a reasoned decision so the parties could understand why I granted or denied. We just didn't say approve or denied. No, we have to provide a reasoned decision. And that takes a lot of work. But I can tell you, after the hearing was finished, I knew the facts cold. And because I prepped the case, I was in a position to give a very detailed oral decision. And for the most part, close to 90% of my decisions were upheld by the Board of Immigration of Appeals. And that was just a typical day. And that's just one hearing. We prepared for 3 hearings a day. That was a lot of work, ladies and gentlemen. Let me tell you. Um, but that was a job that had a responsibility to review the facts, to protect due process. We weren't there to do the job of the attorneys. If one attorney didn't object, I didn't go in there and object on their behalf. Obviously, if I saw that questioning was out of line, if I saw things that were out of order, I would jump in. And yes, as a judge, I would also ask questions because we, as judges, had a duty to what's called developing the record. If there was something in the evidence that wasn't clear, I would jump in and ask somebody to explain what it meant. If we did see that the Department of Homeland Security was apparently uncovering inconsistencies from the testimony of the immigrant or the person, I had an obligation, and we were taught this, to make sure that the immigrant, the person, was given an opportunity to explain any inconsistencies. If a judge didn't do that, that's a basis for appeal. So that's part of fairness. You just don't railroad somebody because they appear inconsistent. You give them a due process opportunity to explain it. And that's all part and parcel of what it's like being on the bench. And those hearings lasted anywhere from an hour and a half to all morning or all afternoon. But our job was to try to finish the hearing on that particular day. It was rare that I didn't finish a hearing because many of these people already waited months, if not years, to have their day in court. And so we really wanted to get behind the facts and give them a decision. So that's just a sample of what we were doing to promote fairness and due process.
And I can say, from my point of view, many years on the other side, is that, and there was room for error by both sides in the sense of, like, if you file something late, the standard is always weighing the prejudice to the government and weighing but really prejudice happens a lot to a person. So if like, this is why the government can't just drop charges on somebody without them having time to respond. But also, if an attorney was a few days late getting evidence in and it was their fault and they said it was our fault, it was my bookkeeping, um, judges did not generally, if it didn't harm the government, which generally it didn't, then they would accept it because the idea was you would to pull the truth and to not try to pretermit cases and get rid of them. So once you had the 24 election, you had barely been in there a year, and here comes the election results, and a couple months later, here comes the new administration. So what were you thinking? Were you thinking maybe you'd make it through, maybe it wouldn't, you'd go under the radar? I mean, what was the mood there?
Well, we had the benefit of Trump 1.0, okay? And under Trump 1.0, you didn't see massive firings or layoffs. You didn't see overt interference with judicial independence or neutrality. So we didn't expect any of that. We did expect that our leadership would change. Those were the director of EOIR, the Executive Office of Immigration Review, the chief immigration judge, and other leadership positions. We expected that that would change. We did not expect that they would be fired. That was new. When McHenry, previous director
Yes.
McHenry, was director, he wasn't fired. He was just moved to another position. But on inauguration day, within hours, our entire leadership was fired. So that was a yellow flag that went up right away. And shortly within about 2 to 3 weeks after that, over 13 judges were fired in mass. That was different. Firing immigration judges was not new. It was the scale and the breadth of the firings that was new. And so it started in February. February 13th was the first wave of firings. Then another wave came in April. So between February and April, morale started to plummet nationwide in all the courts because people were seeing their colleagues, both chief judges and line immigration judges, being terminated for no reason at all. And so after the April firings at the Chelmsford Court in Massachusetts, we had four what we call probationary judges that were up for renewal. When I say renewal, they usually get converted after 2 years. 95% of the judges that are probationary normally get converted, unless there's some complaint against the judge or some overt bias or prejudice. They'll be converted. But in our court, three of the four were fired. And they fired three really good judges. And that's when I knew that this was not going to stop. And I took so much pride in decorating my offices with photographs and monuments to the New York Yankees and other nice little motifs just to make my office livable while I was preparing for cases. But after April, Mark, I cleaned out my office because I knew that this slow moving train wreck would eventually come down to me. And I also saw that these judges only got 15 minutes to pack up and leave. Wow. And
Now,
they were
three out of how
escorted.
many? Three out of how many? How
I
many
mean,
judges were in the court? Just so people know the
we had
scale.
about 18 judges at that time, starting in
Oh,
February.
okay. That's
Actually,
a
in
big court. That's a big court.
September of 2024, Chelmsford had 18 judges.
Okay, so 1/6 in one day, right?
Yep.
So that's three. Okay, so yeah, this is, and that was right away, and they weren't told why.
No, they weren't told why. And it wasn't just Chelmsford, it was Chicago, it was San Francisco. The big moves later. I mean, the San Francisco court has been totally decimated and closed. All judges are gone there. New York City, Federal Plaza, Broadway. I can't tell you how many judges have been fired there. Last week, three judges out of Chicago were fired, one in Sacramento. The carnage hasn't stopped. And so when I was terminated in July of 2025, I think we were down to seven judges from 18.
Hmm.
And of course, the backlog continued to grow. So firing judges did not help address the backlog. It did the reverse. And so we knew that the interference with judges was part of the problem here. There's examples of how EOIR told judges how to rule in specific cases. And I'll get to that later on if you want, because it's happening even to this day. And
Yeah.
people should be aware that these judges are not operating in a neutral environment.
Right. So they got they were getting rid of them on a large scale here. I mean, and a lot of the people they got rid of were people that were hired from the private bar during the Biden administration, and many that I know who they were been practicing about 10, 15 years. They were fairly new, some a little bit less, and they could have settled in for a nice long career. They were in their mid 30s. They had been some of them were really young, and they were some of the sharpest people that I knew, like close friends, became judges, and there was no rhyme or reason of when they were getting fired, but they were all on their way. And others, so you I mean, what did it do to the court in itself? Because one of the things in a court is I know judges, having worked with lots of judges, you speak to each other about how you rule on things. You know what kind of cases you there's a camaraderie that's necessary, just like it is among lawyers. So how is that affected?
Camaraderie was being undermined. I mean, all of us knew that we were going to be terminated. And that's a pretty depressing thought, knowing that you still had to prepare for cases every day, knowing that your time was going to be up. It's a very unsettling feeling. Of course, all of us who were private attorneys before we became judges were required to close our practices, which we gladly did. We were very happy to have a chance to be an immigration judge. So we were told to close our practices. We did. We did not expect to be fired under the conditions that they outlined. In fact, they changed the parameters of how we were fired. We had parameters or benchmarks to meet. In my case, I exceeded every benchmark they threw at me. I was required to close some 700 cases per year. By the time I finished, I closed 2,488 cases. I probably gave oral decisions in close to 300 cases. I made sure that all these motions that were filed by lawyers, motion to withdraw, motion to continue, a motion to advance a hearing, all these requests by lawyers, the target was to respond to those motions within 20 days. And we had an avalanche. I kept it within 20 days. Lawyers got a response when I was on the bench. Um, so if it was based upon our performance, none of us would have been fired. None of us. What's ironic is when they fired me, my denial rate at that time officially was about 76%. So I wasn't exactly a bleeding liberal here as far as the administration is concerned.
No, that's
But
low.
when they factored in my Chelmsford decisions, my average was around 54% in terms of grant rates. Um, so there was no rhyme or reason. After April, nationally, people started to resign. They took the fork in the road from Elon Musk. We were required, Mark, check this out. We were required every Monday to report back to Elon Musk about what we did the previous week. If we did not submit that report every Monday by 11:59 p.m., we were fired.
So people forget this, and we know this in DC because it happened at all these different agencies, was that the Doge committee that Musk chaired had people overseeing all kinds of government workers, all kinds of government workers, and including, and you think immigration judges, so they're overlooking your work. You've got a case that, you may have to, there's a very sympathetic reason to continue it or to wait. There's a lot of there. Immigration court isn't just you go in, you do your case. Sometimes it's you've got you've got a child who's 20 and they can apply for you when they're 21. So you'll say, okay, I'll continue the case for you to be able to wait for him. Or you've got somebody who's really an orphaned or special immigrant juvenile who's orphaned by at least one parent, abused, neglected, and you have to wait until they can get a green card through no fault of their own. And there are things that were done, where judges could say, look, this is in the interest of, it's in nobody's interest to deport this person. There's nothing negative in their record, and it's just a matter of they have to wait, but they're in the process and doing things the right way. And that was common across the board ideologically from judges. So that's something that I know changed. And so when did that change, that you were told to just not be lenient on, were you around for that, for them to tell you to just not be lenient on those kinds of things?
Yes, it started in April of 2025. The then director, acting director, Cersei Owens, issued a memo to all judges nationwide. It was called a pre-term memo. And this memo, Mark, told judges that if you see an asylum application that on its face doesn't quite meet the requirements, then you don't have to have a hearing. You can just order the person deported without a hearing. What the director neglected to note is that the agency's own regulations obligated judges to give these people 30 days to correct an insufficient application. They forgot about their own regulations. So we saw trouble coming there. Then matters got real dark in terms of interfering with judges' independence. In May of 2025, when ICE started entering the courthouses.
Oh yeah.
This got real dark. They entered the courthouses in New York, Chicago, Chelmsford, Massachusetts, Boston, San Francisco, the big courts. When they came into my court, I called up my chief judge. I said, Judge, we got ICE in the courthouse. What do you want us to do? And the judge wrote back to all of the judges in Chelmsford and said, stay out of the way. That was our guideline. Stay out of the way. And I called the judge. I said, that's not really a very useful guideline, Judge. Why don't we talk about it a little bit? Because for the first time since I was on the bench, the government attorneys were actually appearing in person in court. Up till then, it was WebEx. Now they were coming into court and they started to do something unusual. They asked to dismiss the cases. Normally, if you dismiss a case, it's actually not bad news for the client or the respondent. They get to stay indefinitely. They don't have legal status, but they're not being pursued for deportation. But things changed in May because if we granted the government's request to dismiss the case at the first hearing, the master hearing, the case or proceedings would close, they would stop, and as soon as that person walked out of the courtroom, they would be arrested by ICE and placed in detention and processed for removal. So it was a very serious consequence now if we granted. And for the first time, we were told to grant them. And I would tell my chief judge, you mean just rubber stamp them? And he said, well, unless it's defective, grant them. Why were we being told to grant? Because a memo was issued nationally by one of the regional executive offices of review directors that said we no longer need to give the unrepresented immigrant 10 days to reply to this motion. We can grant the motion at the hearing itself. This was a complete change of policy and regulations. We had an obligation to give these people an opportunity to understand what the motion meant. And we should have been able to give them 10 days. But the government was telling us, don't give them 10 days, grant the government's motion. So what happened in May is the so-called firewall between the Department of Justice and the Department of Homeland Security broke down. We now became part of the deportation machine. We were now being told to rule in a way to accelerate the ability for the Department of Homeland Security to arrest, detain, and deport people. This is when the whole immigration bench fell off the rails in terms of neutrality. That was a benchmark for these courts.
Well, and it also, one of the big lies that is that that they used to create policy was to say that we need, the first time around they tried to do it about detaining families, and there were sort of trial balloons, but in this one they said, look, during the campaign, they threw out these ridiculous numbers about people not showing up in court when the vast majority of people do. And but this creates a self-fulfilling prophecy, because if ICE is outside and if you're going in there, they're going to do this and you're going to be detained. And we've talked a lot, we've had different a lot of shows on detention, and I've been to outside Alligator Alcatraz and talked to folks that were there, and some of the worst places, but really everywhere is the worst place now. And the nobody wanted to be detained not knowing anything and what happened to them and the danger, so people wouldn't show up just for their own safety, just because they wanted to feed their kids, just because they had to be the breadwinner. So here they are having paid a lawyer saying, look, I'm just not going to show up. And I know my colleagues and I were pushing our clients. Look, it was a really difficult situation, because we can't ethically tell somebody to violate a law, but the abuse of the law made it so that we couldn't strenuously tell them, hey, it's in your interest to show up there, because they were being set up and it was a really difficult situation. So we had to just say, you're obligated to go. And then they could use that. And there's also the memorandum about immigration lawyers, that's always been a part of Trump's that was from the first time too, with when Jeff Sessions would attack the immigration lawyers, in that calling it dirty immigration lawyers. And that was sort of a famous quote from him. So it creates this entire everybody has to be part of it in one way or another, and there's no good way to be part of it. Um,
Mark, what you're talking about is the catch-22. The government created a no-win situation for the immigrant. If they show up to court following the rules, they could be arrested because they're following the rules. They're going to court. If they don't show up, then the judge most likely will issue an abstention order ordering their removal. So they were placed in this no-win situation. In retrospect, as of June 2026, uh, Southern District of New York prosecutor Clayton, who was just nominated by Congress, I think, for a security position, that Clayton revealed to the federal judge that they received a memo from ICE that revealed that ICE had no legal right to arrest people in immigration courts. And the prosecutor apologized to the judge for this misinformation. Um, so ICE has admitted on its own that they have no legal right, had no legal right to arrest these people in immigration courts. Further federal courts have solidified that. But that's the irony of what's happening. And it's part of the MO. The MO is we don't care what the law is as a government, as an administration. We'll just do what we want. Let's create the damage. By the time the courts catch up with us, the damage has been done. And that's exactly what happened here. Hundreds, if not thousands, of people were unlawfully detained. Many of them were forced to self-deport because they couldn't withstand the horrible conditions in detention. And so the damage was done. And so this is very unfortunate. It shows not only a complete disregard for the law, it was inhumane. It was contrary to the laws that we had set up to give these folks their day in court. And this government just trampled right over that. And as you know, the president had no patience for due process. He didn't want to wait, as he said, 200 years for the courts to make a decision. Well, I'm sorry. That's the law in the United States. It still is the law. So that's a little backdrop of
right.
what happened with
So
ICE. But
did you end up so you just had to had to grant those motions?
I did not grant those motions. I'll tell
Hmm.
you why. Because each of the what we call respondents or immigrants had pending applications for asylum. So when the motion was filed orally by the government attorney, I would look at the individual who had no lawyer and I would explain to them what the motion meant. And I would explain to them that if we close hearings, that they could be arrested by ICE, and whether they wanted to pursue the filed application for asylum. And of course, they said yes. As soon as they said yes, I looked at the attorney for the government and I say, sir, ma'am, your motion's denied. The respondent not only wants to pursue their application, but let's not forget the Department of Homeland Security initiated these proceedings. They filed charges called a notice to appear. You made a decision to bring this matter to court. I now have jurisdiction as judge as to whether we close it or continue. And this person has a due process right to pursue their application because they are eligible. Motion denied. And that's why how I denied them.
Oh, good. Yeah, no, that's good because I think one of the things when people think about it, we try to compare it to criminal court because of the penalties, but it's not that's not exact either because if a prosecutor drops a case in criminal court, it's almost there isn't a condition where it's not good because only you either win or something bad happens. Whereas immigration court, people are out of status, and it used to be that some relief, some ways to get a green card could only happen in immigration court. And in the very old days, you used to actually want your client there so a judge could hear because a judge, people don't think judges hear, the positive part. People think the deportation court, but judges grant green cards for family on family petitions. Judges grant um, domestic abuse. They can cancel a deportation for a spouse that's been abused. Judges grant humanitarian protection. Judges grant green cards based on hardship to families of different levels. So much of this is people getting their day in court is not their day in court just to defend themselves, but their day in court to present to a judge with on cross-examination where the government is there to present another case, a contrary case, um, and they get to bring witnesses and it's a full hearing. And that is completely chopped off when they say, "Oh no, we just forget about it. We didn't do that." And so, um, and that's in that level the disrespect for the law. So you okay? So this was in May, and so uh, and you were saying before you knew you were probably it was a Friday, and Fridays all these bad cases come out on Fridays from the Board of Immigration Appeals, and also these judges are getting fired. So Friday afternoons at 4 or 5 o'clock is when this happens.
Right.
So you
Yep.
knew you sensed that something was going to happen. You got word, right?
I knew exactly when it would happen because they were firing probationary judges. I was a probationary judge, and my 2 years was coming up. So I knew within a week or so they had to make a decision. And I knew it was going to be on a Friday. So that's why I could predict when it would happen. It was no surprise to us. And I got the same exact email as my colleagues did. And it was a Friday. So the following Monday morning, I turned in my card and my computer, and I was gone. That's it. I was no longer a judge. I had to break my lease on the apartment that I leased. That cost me a couple of dollars.
Yes,
I had to pack
Massachusetts is
up and move
crazy.
back to, I had to move back to North Carolina. Other judges came from Texas, from Hawaii, from Europe. They fired one of my colleagues who was a 20-year Navy veteran. He was a chief judge in the Navy, and they fired him. They fired him. What's ironic is that some of these judges then applied to work for the Department of Homeland Security, and they were hired.
How crazy. Wow, that's great. Yeah, that's crazy. I
It's
mean, the
crazy.
so then
But
okay, so then you're speaking out in practice, and so what are the things I wanted to touch on a couple of the things just so people know. I mean, that was one thing that was outrageous, but really beyond the personal firings and the things you're meant to do, which cut off due process, there's a couple of other things, and we tried to, talk about them, but you can't emphasize enough because they keep getting resurrected. But these uh, beyond the immigration court is the Board of Immigration Appeals. So firing people from there and stacking the Board of Immigration Appeals with some of that I knew the worst judges around the country were, as far as due process goes, um, and they would just they would just choose cases and make decisions. And most of the cases that they chose were cases of people who were unrepresented.
right.
So you go to court without a lawyer and you're going to, make mistakes and not present things. And they would say, okay, well, we're going to deny because these things weren't, this case wasn't strong enough, and then make a larger um, point, a larger holding of it. And then judges are being held. So cases that required hardship um, were then considered the standard was way too high. They started to say, well, if you're going to get a green card, there's a discretionary factor. Oh, well, you came through the border without inspection, even though the law forgives it in certain situations, or you overstayed your visa. We say, well, that's discretionarily a bad thing. And because you came in the U.S. without inspection, we're not going to grant you a bond because you're going to be a flight risk because you didn't report yourself when you first came in. Like they could just use their, really white supremacist
Let me,
ideology
you're
to
talking about the dismantling of due process in the Board of Immigration of Appeals
Mhm.
pre-Trump 2.0. If someone wanted to appeal an immigration judge's decision, they would file an appeal with the Board of Immigration of Appeals. And we had about 25 uh, BIA judges before the inauguration. Trump quickly fired around 12 or 13 of them and appointed mostly his own people. And as you say, the board now issues decisions. About 95% of them are all anti-immigration. They're doing things which are totally unheard of. One example is where they will state that attorneys, lawyers, don't have the right to necessarily close or provide closing arguments for their clients. Of course, attorneys have a right to a closing argument. That's where an attorney can determine what a judge should consider in terms of weight. That's where an attorney shines for defending zealously their client. But the board said, no, you don't have that right. It's a privilege, not a right. There are other ways that the board has dismantled due process. They've also when there's an appeal, they're not supposed to go back into the facts and provide their own judgment on the facts. That's the immigration judge's job. So that the way they're evaluating uh, decisions or rulings is totally contrary to the way things have done in the past. But the most egregious thing that the board has done, if you want to pick out one that's really bad, is matter of Hurtado, September ruling of 2025. Here, the board dovetailed on the ICE policy that Mr. Director Lyons issued on July 8th, 2025. What did ICE do for the first time? They said that if you enter the country without a visa, no matter how long you've been here, 10 years, 20, 30, if we arrest you, you do not have a right to a bond hearing. That was new. Of course, in the past, since 1996, if you were arrested within 2 years, you could still be placed in what's called expedited removal. But to make a long story short, now people were being picked up everywhere, not just criminals. And they were not being given a right to a bond. So lawyers for immigrants were trying to file motions to have a bond hearing, and the judges would now say, we don't have jurisdiction. The government has changed their interpretation of laws that says everybody is now mandatorily detainable without the right to a bond. So all of a sudden, Mark, people started flooding the federal courts with habeas corpus petitions to force the courts, the immigration courts, to hold a bond hearing. And then things got really wild. The federal courts started to weigh in, especially in California. The Middle District came out with a nationwide injunction that said this policy is unconstitutional. It violates the Fifth Amendment for due process protections. And what did EOIR do? They instructed their judges through Chief Judge Teresa Kelly. She sends a memo and tells all judges disregard that federal ruling. You are still not going to accept bond hearings. A complete uh, disregard and defiance of federal orders. And so we have a constitutional crisis. We have an administrative agency defying federal court orders that have nationwide implications. And so the complete breakdown of the rule of law between the immigration courts and what the federal courts were ordering was now in place by November, December of 2025. And this matter will go to the Supreme Court, but most of the circuits around the country, except for the Fifth and the Eighth, have all ruled that what the government was doing, mandatorily detaining people, was against the law. And so the Supreme Court's going to have to hear this eventually. But this is the kind of violation of people's rights that was taking place. I mean, their liberty rights were violated. They were put in a jail. Remember, immigration is not criminal court. These are civil proceedings.
Right.
That's why they don't get a lawyer.
And we've talked about it here. We've talked about it with in different contexts about how much that people that are in detention, there's a certain amount of time, and after a certain amount of time they just can't, they can't stand it, and they just do anything to leave, and they give up on their cases because it is endless. I mean, you have one of the things of all the judges being fired is when people are in detention. Last year I had a couple of times where my case was canceled that day because the judge was fired, and so then I had to wait another 3 weeks, and the person's sitting there. And it used to be, just, and again, this was never, I call the 96 law one of the worst laws in U.S. history, and they use a lot of that. That was a horrific law, and you put it on a platter, and they built all these detention centers. It's so, but the idea before was that if somebody is detained, you talked about it. Like if you had a detained client and you were late, meaning the private attorney was late getting documents, and you said to the judge, or you were trying, they said, look, this is, the government would oppose and say, this is a government expense that they're detained. We need to, the idea was a speedy trial because the person's detained. Well, if they, and often people that were detained because they were mandatory detained because of crimes they had committed, which again, were not necessarily violent or huge, but the law outlined it. So there was a parameter, and you knew who was there. So the people that were detained were people who, maybe they served time, maybe they just had like a, a few grams of weed at some point, and they're just not allowed out during that period. But the idea was, detention was, there was one judge in each court that kind of did the detained docket, and that was it. Now it's like it became this massive increase, for anything. And people I mean, first of all, it's almost impossible to represent somebody adequately when you're at the mercy of when they get phone privileges or video privileges. Um, you can't, you're not going to see them. They're going to take them from states in the Northeast. And, you talk about the Fifth Circuit. I think the ACLU case that they were saying that 70% of all detainees are in Texas, Mississippi, or Louisiana, which is where this huge number, and it's 70% of detainees are there. And so, and they move them there, and they move them there quickly. So you could be picked up like here in Maryland, and there's no detention in Maryland. And in a few days, you're in Louisiana, and all of a sudden, here you were, your case was in front of a judge here. You were working on the law of the Fourth Circuit, which is a lot better than it was when you and I started, when it was bad. But or the Second Circuit, you're dealing with New York law. You're dealing with your judge in New York, your cases before them. They pick you up, then all of a sudden, you have some detention judge in Louisiana or Mississippi, often out of, phoning it in from Houston with some massive docket, and your case starts over, and you have a different body of law, and you're mandatorily detained, which is one of the crazy things. I want to touch on the what I think is something that was shocking. It shocks people to the core when they hear it. And when people hear these things, they think, okay, something must give. Like I right now have a military spouse who's kind of around the news and is on Face the Nation and other things. And so my people in my family and life, and some are, really conservative. They're like, no, tell me what's going on. But then they're bothered by it because they see it sort of viscerally. And so the idea of talk about like what is asylum and protection, and where does it come from, just briefly, and then what is this administration's really warped view of that and really cruel view of that.
Well, the current asylum regime and laws really come out of the World War II era and the Holocaust, the genocide against the Jews and the Gypsies, um, and the horrors that we inflicted on thousands of refugees that tried to enter the United States. We turned back their ships. We wouldn't accept them to come into the United States for their safety. They were being persecuted by the Nazis. And our State Department turned those ships back. They ended up back in Europe, and many of them were killed in the concentration camps. And to prevent that from happening again, and after the full horrors of what the German Nazis did, the UN finally passed refugee conventions. And the 1967 convention finally was passed by the UN. At that time, the United States did not adopt it. It took until 1980 before the United States domesticated and adopted the international law on refugees, which finally put into U.S. law protections for people that were fleeing persecution based on their politics, their religion, their nationality, or obviously their race. And there's another category that people have claimed asylum. It's called persecuted social group. In the modern days, today, many people claim, gender discrimination or LGBT and other types of persecuted groups that are targeted specifically for your affiliation to them that you might, can't change. Maybe you're a whistleblower. Maybe you were a former policeman. You can't change that identity. And it's called immutable. And those characteristics target you for persecution, either by the government or by drug lords or by other sectors of society. And if you're being persecuted or harmed, physically or psychologically, you can seek refuge in other countries in addition to the United States. And we have laws up till recently where if you set foot into the United States, whether through a port of entry or if you came in illegally through in between a port of entry, as soon as you set foot in the United States, you had a constitutional right to seek asylum. It was part of our domestic law. And that operated all the way up until about, I don't know, a month and a half ago, when finally the Supreme Court of the United States said, no, the government has the right to, what's the word? I forgot what it was called. They can hold you back. They can prevent you from seeking asylum because according to Justice Alito, as long as you haven't entered the United States, you can't apply for asylum. So the protection from harm, physical, psychological, historically has been a place where people can come to the United States to seek refuge and protection. Laws were designed by our government to address that problem. And that law has now been totally hijacked by the United States government in certain ways. The Supreme Court has now given the government the right to abrogate its obligation under the refugee protocol that we adopted. This is really wild. Supreme Court sanctions that abrogation. And now the government is saying that you are no longer necessarily given a right to an asylum interview outside of court. So if you apply for asylum,
Oh, yeah.
you're being told they can just ignore your interview and send you right into immigration court proceedings. The problem with immigration court proceedings, Mark, as you know, it's adversarial.
Yes.
The courts have been hijacked. And so it's just an easier way for the government to deport people that otherwise may have a legitimate claim for asylum. So the asylum framework, the asylum law in the United States has been totally hijacked, both by the Supreme Court and by the administration.
Well, and also, I guess, what one of the things that's really shocking because, yeah, there's the asylum office where if you're not in court, you can apply there and you go for an interview, and it takes forever, but it's not adversarial in the same way, and they just get information and then they can decide. And it's problematic being adversarial anyway, because you're asking traumatized people to go into court. And look, I get nervous even after all these years. I get nervous every time I go to court, and I don't sleep great the night. It's hard for me to sleep great the night before, and it's after many years. So it's for them to go to court. It can be so hard. And most judges were cognizant of that and treated it as best they could. Most were, and now, um, you know, I mean, these judges are kind of miserable. They're not. I mean, and when we say these judges, I mean, who's backfilling all of the positions that like
The
who's
backfilling is by military judges called JAGs. These are military judges that are replacing the other judges like me that were terminated. These judges have virtually no experience in immigration law. In fact, the previous requirement where these judges had to have at least 7 years of
yeah,
immigration law experience, they did away with that.
right,
So any attorney can now apply to be a judge, which is horrific.
and
Even
they
the
do.
training has been truncated from a full month to 2 weeks. And so these judges are ill-equipped to really handle the nuance, complexity of asylum and other laws on the bench. That is deliberate. That's why the denial rate for asylum by immigration judges has gone from about 54% to 93% nationally. Only 7% of the asylum applications in the last 6, 7 months are being approved. Um, there's a reason why this is happening. This politics of cruelty, whether it's in the detention centers, whether it's the hijacking of due process, whether it's the termination of judges. You touched upon it briefly. You use the word white supremacy. That's very much in play here. And I'm going to show you exactly where it comes from because it's verifiable. J.D. Vance, Stephen Miller, and others are out there promoting a new ideology of who a real American is. According to Vice President Vance, you're not a real American unless you have dirt in the United States, meaning that unless you've got ancestors that go back to the American Civil War or even the Revolution, you're not classified as a real American, that real American culture. And the only way to protect that culture is to make sure that these non-cultured Americans who are coming into the United States poison our blood. So if you're a naturalized American, you're not on the same hierarchy in terms of power and privilege as these real Americans that J.D. Vance promotes. That's a fascist blueprint for who has power, who has the right to decide. So the dehumanization of these people is evident in Haiti, for example. In Haiti, they want to cancel TPS. Yet the State Department says any American seeking to go to Haiti should not go. It's too dangerous. Well, you're telling American citizens don't go to Haiti because it's very, very dangerous. Yet you want to ship about 350 people back into that dangerous environment. What is wrong with that picture?
Well,
But
you
what's
can't
wrong with
fly
that
there.
picture is the
There's no
complete,
commercial flights. The airport's closed. You can't because they
airport's
get shot
closed.
at, and it's and you know we and people know I did a show last summer in Springfield, and one of the things that the media didn't talk about. Everybody knows the cats and dogs, and it was, but what people didn't know is how um much after uh that they had to close the university there. There's the Lutheran University. They had to close it because white supremacists like Proud Boys and Boogaloo Boys and the whole crew that was the January 6th crew. They were marching the streets of Springfield, and they people were afraid to go out, um and the people that were they lay the blame on JD Vance because he's from there. He's from about an hour away.
And Vance admitted that what he was spewing was just a fairy tale. He
Yeah,
admits this.
yeah,
This is how bad it is.
yeah. And
Um,
so they're playing on that, and I think and the beautiful thing, not is that and we've had many people, is to see the resistance that's out there and to see the rejection and to see how people have woken, and this has woken people up. And there is that out there, and it is encouraging. But one of the, so we're talking about these things today, and usually I will have people out there organizing and inspiring and in really hard places like Tennessee and Michigan, all these different places. But this is but sometimes we gloss over the things that are really uh how it got this bad. But I guess what I'm referring to is this, you know where they can send somebody, and they did it. I have the order where it's all on appeal, but where they will take somebody who is from Guatemala, say, and they're applying for asylum from Guatemala or Russia, and they say, okay, well, you know what? We're going to stop the hearing and send you to Honduras, because Honduras has an agreement with the government, and they will take and the government has to certify, the State Department has to certify that they have an agreement, and that there will be a fair process in that country. Um, some countries put them in solitary confinement and they'll give them a hearing. Some of them just fly them, they land in Guatemala, they fly them back to their home country. And the United States says, well, we can't, um, we can't help that they do it. That's not on us. And there's a principle of, do you speak French? I don't speak French, so I don't know how to say non-refoulement, but for people who just read it, it's non-refoulement. If you read it's a French word, which means, it's the principle that you don't ever, it doesn't matter whether you have Charles Manson, you don't ever send somebody back to a place where they're going to, in that case, be tortured. And even there's a convention against torture. And I had a client who's still in jail 40 years for murder, but they were a gay Iranian woman who was a Wiccan, and and her father was involved with the Shah's secret police, the Savak, and so she would not have lasted in Iran, most likely. And so she has Convention Against Torture protection. She's still in regular jail, but when she gets out, they can't deport her. But they can send, and they used to not send them to other countries. They've been doing that, but even they've upped now to just send people to these countries. And so somebody's detained, they're in court, and they're about to present their asylum case from their country, and they're flown to some third country that they've never been to. And so that is, I think, the largest stretch in my view. Um,
You mentioned the pretermission, the interference with asylum. These are people that have applied for asylum. They're preparing for their hearings. They get to their individual hearing. They're sliding into home plate, basically. Their day in court's right there. And as you say, the government says, oh, we move these people to a third country. And the judges are signing off on that, moving people to these countries that have horrific human rights conditions, and telling these applicants, we're removing you. You're not going to apply for asylum here. You can do it somewhere else. that's undermining the non-refoulement position. It also means the Supreme Court violated the very principle that you talked about, non-refoulement. You don't send people back to a place where they will be killed or tortured. And so for the Supreme Court to sanction that a few weeks ago by allowing the administration to prevent people from applying for asylum, and also the government's use of preterm mission to just hijack asylum applications in midstream and just send these people off is horrible. And so that's what's happening right now. It's really, I can't put
And it's a
words to how
lie.
just
It's dishonest, and that's where I think people need to rise up is to just and understand that point. Like we're explaining a lot of things that are really technical, but it's dishonest because they're pretending something is true that's not. And the decision in that one, because this is something that I don't think I've talked about enough, but that was in your old circuit. That was, and I had a case that was very similar where they tried to, somebody applied, you have a year to apply for asylum. And then if it's more than a year, you have to have an exceptional circumstance or something like that. And I argued this was a Guatemalan case, and it was a few days, it was like 2 months late, and the person tried to file their own application and it got rejected. It was not meant to be the reason they put that law in, which is still a bad law, but they were reticent to put that law in because they knew that it could mean that people who needed protection could be sent back to their deaths or under a technicality. And that's not what they wanted to do, even in the awful 90s when they were doing this. And so there was a case out that was in the First Circuit, which is in Massachusetts, covers New England and Puerto Rico, New England except Vermont and Connecticut, or it's with New York in the second. But they, and so it was somebody who there were four different people, but the case that was closest to mine, which was Guatemala, was there was a Guatemalan gay man who traveled through the U.S. and in Mexico was raped in Mexico and um came to the U.S. and asked for asylum. Well, they were put on a bus and sent back to Mexico, dropped off in Monterrey. The Mexican government said, "You can apply for asylum here, sure, but we're going to jail you, and or you can go back to Guatemala." And they were so petrified of being in a jail, having been raped, that they said, "Okay, I'll go back to Guatemala and hide out there. I have better chances." And it went up to the Supreme Court because a judge put a stay on that policy while the case was going through, a federal judge, because they thought, okay, this policy isn't, they're going to lose. The federal government's going to lose on this, the administration. So they put a stay, and the stay was lifted by the Supreme Court without comment. And Justice Sotomayor wrote a 20-page dissent saying, this is what's going to happen. These, think El Salvador, think of, what we've seen in the news. So, Justice Sotomayor made that point. And I took that to court with a good judge, but the judge was like, I don't want to hear about it. And then the ICE attorney went ballistic and said, you're just delaying and all that. And I said, this is the Supreme Court. Like, you're not listening to them. Who are you listening to? And that's the point is, and even when they are so, like you were saying, on your face, oh, we're just ignore those higher courts. Okay, you can win, but at tremendous expense to the individual and their family, beyond the legal expense, the loss of a breadwinner, the trauma that it causes to U.S. citizens. And lately we'll revisit. We talked about veterans, but I've got a veteran case now that's out there where they're families of veterans. It's there is no and you were saying like even a 20-year Navy judge fired. Like there is no um limit right now. And so this is the thing that people that's been in the media, but really not enough, is that they're deporting people to these countries where they don't know the language, they haven't been there, and they're using it as a weapon. Um, and so that's something that is not, I think it's hard for people to get their head around, but it is what's happening. And, uh, you know, certainly people on the outside need to understand that.
Mark, let me end with one point here
Sure.
because
Yeah.
Steve Miller brought this up in the last 48 hours. Steve Miller has criticized these people on TPS, like the Haitians, like the Somalis. He has categorized these people as not only uncivilized, but unable to run a country. They just don't know how to do it. And he doesn't want to import people from these destabilized, horrific countries. And in other words, they'll poison our culture. They'll disrupt our civil liberties, according to Steve Miller. But what Mr. Miller doesn't talk about is how our country has helped to destabilize the very countries he's criticizing. Our foreign policy has interfered with every single nation in this hemisphere. We have trained the death squads at the America School in Fort Benning and in Panama. We have contributed to the slaughter of women and children in Guatemala. Just Guatemala alone, we instigated a civil war that led to 200,000 people being killed between 1954 and the early 70s because the U.S. government, through the United Fruit Company, didn't like who the elected leader was in 1954. So we instigated by arming these people to have a coup, and that led to a civil war. And most of the people that were killed, over 170,000, were Mayans, indigenous people in Guatemala. That's just one example of one country that we have helped to destabilize. And you wonder why they're so desperate to come back up this way to survive. So Mr. Miller needs to have a history lesson and understand that we as a nation have contributed to this mass migration to our borders. We have a moral duty to make our laws equitable. In other words, equitable here means just follow the laws that we've implemented. We're not even asking for new laws. Implemented the asylum refugee protocol, follow it. So there's a historical context here
Right.
which explains why people are coming here, and to just blame them as being uncivilized or barbarian or savage, as according to what Steve Miller and J.D. Vance and others have promoted, is just inhumane. Inhumane.
Yeah, no, and I think that that's also part of, the whitewashing of history also. And there's a fabulous book, and it's actually a movie called and when I taught at Maryland, I taught with his book is Harvest of Empire. And it's Juan Gonzalez, who is the co-host of Democracy Now, and he journalist from Chicago, former Young Lord, and it's a fabulous book, and it talks about that of how the U.S. Creating an empire in the Americas has, of course people are going to come here, and the destabling of their countries and the affecting of their elections, and that happened. It happens with pretty much every administration except Carter was like the one exception, but it really was and it really was on hyper speed now. I mean, we see in Honduras, their former president was convicted in the United States to serve 54 years, and President Trump
Pardon him.
pardoned him,
Yes.
and
Yeah.
and now then they brought Maduro here and charged him. So it is not, there is nothing. So people probably think, because you think somebody did something wrong, and then you don't think, is my government that corrupt, that vicious? And the answer is yeah. I mean, look in Cuba right now. I mean, the level of um, viciousness is very heavy, and I do think, with Venezuela, I mean, by taking out Maduro, they is to control much of the oil and to have wealth, in a case also personally brought to him. So these are also, that is a whole
Different
another
discussion.
topic. Yeah, yeah, it's a whole nother discussion. But then these are the things that judges now. I mean, at the best ones, because this judge that I had is very good, but she was like very angry, and I said, look, in a context, and I had somebody with USCIS who um, they brought, oh well, you have these charges and conviction in El Salvador, and it's like, for because he reported to the police, and I said that's the most, that the judiciary in El Salvador tries 900 people at a time. There is no process there at all, and you're relying on their conviction when he wasn't there. With no evidence or anything else, and it's like, well, it's there, and you just, I mean, there's a hope in the United States. There's also a history. There's a hope and there's a history, and we need to, push for that hope, and people are doing that. And to say like, so I think the point you make is a great one to end on. Is we talk about really these horrible things. Much of it is a continual line, like what happened in the Americas, pretty much is a consistent line. And you know, hyperextended right now, but so people need to decide, like, what are we going to be as a country? What are we going to be in our communities? And people are rising up. I mean, I was, represent this little concrete pouring company that has all these Salvadorans, and their boss, who I'm pretty sure is probably, a conservative voter, not, certainly not anybody's liberal. And he's like, I wrote to President Trump about how this is going to affect my work, my business. These are my people. This is who I trust. And whenever I would debate people from FAIR and anti-immigrant groups or all of that, I would say, look, we can say what we're going to say, but people in the United States in general are not white supremacists.
No,
I
they're
don't
not.
believe that. I don't believe that. And people like diversity. And I've been to Ohio, and the kids in that community were really upset because they and their teachers saw how cool it was to have this Haitian immigrant, how cool it was, how much for their town. And their town is it was a dying Rust Belt town, like much of the out there. And historically, that's what's built the country, all over the country, not just, the coasts, as they say, the coast. No, you look where Chicago and Minnesota, and so there is this hope. But anyway, George, thank you so much for, you know, uh, bringing to light what really was happening in these courts.
Thank you.
We'll be following it, and we'll get you back. We'll get you
Thank you.
back as things
It's a
happen.
pleasure to talk to you,
Great,
to speak in front of your audience. Thank you for inviting me.
great, and you take care.
Take care. Thank you.
Bye bye.